I will give you the cliff though. So in this hypothetical, Wolf Popper has been retained by an investor who lost money in Enron and wants to take an active litigation position in a class action. So let's say that investor goes forward and we will draft a complaint for the investor and we will send that complaint to the investor along with some other documentation for them to review. And if the investor approves it or the client approves it, we'll file the complaint on behalf of the investor, now the plaintiff, in court. It'll get served on the defendants under the federal securities laws. In class actions alleging violations of the federal securities laws, it's not the investor that files the first complaint that leads the case on behalf of all other investors. It's actually an investor called the lead plaintiff. And the federal securities laws set out a procedure for any investor who has been damaged, basically any class member, to ask the court to allow them to serve as the lead plaintiff. So under those laws, 60 days essentially after the complaint is filed, any investor who wants to lead the case will file a motion for appointment as lead plaintiff. The court will appoint the investor, typically who has the largest financial interest and is also adequate and typical of the other members of the class. Largest financial interest typically is assessed by how much money you lost, and adequate and typicality, you purchased the same share, you purchased it or same security, you purchased it on the open market, you are able to supervise your counsel, you don't have a propensity for fraud. These are the elements that the court may look at to decide. Once the court appoints a lead plaintiff, let's assume in this case our client has filed a motion, has the largest loss, and has been appointed the lead plaintiff, we would do then an even further investigation, and we would then file an amended complaint. And that amended complaint would have much more detail than the initial complaint. And I didn't mention this earlier, but we also do a thorough investigation before filing the initial complaint. Once an amended complaint is on file, and it will have more detail, it may include information from confidential witnesses or additional information that's come to light since the initial complaint was filed. The defendants then typically will make what's called a motion to dismiss. That is a motion claiming that the complaint does not allege facts sufficient for legally it to go forward. It's not a motion saying on the merits of the case. It's a motion saying that the complaint is legally insufficient. When a stock does tank and we look and we see that our clients that suffered a loss in that security, we will dig in, as Adam said, and we'll look for disclosures that caused the stock price to go down. And then we will compare that to what the company or its executives have said before. So like the federal securities laws are not insurance against stock going down. There is risk in investing. The federal securities laws only make it unlawful to do like certain things. And if it looks as though a company has done those things, then there may be a case for securities fraud or other securities violations. Keep in mind, if a case is filed, those then are allegations. And then if the case goes all the way through a trial or summary judgment, perhaps you prove the allegations, there is a settlement. So the largest category of things that the federal securities laws make illegal is to make a materially false or misleading statement. So that's either an outright lie, we made $100 million last quarter. If that turned out to be true, the truth in that case is probably our audit committee is investigating our revenue recognition policies for the last quarter or for the last 3 quarters. And we're advising investors not to rely on our publicly filed financial statements until further notice. Then the stock price goes down. Just to use that example, you have an alleged false and misleading statement. We made $100 million last quarter. You have a disclosure of the truth or an alleged disclosure of the truth, and the price goes down. And then there are other elements of the claim that you may have to prove, such as reliance, economic loss, which is that you lost money on your investment. You held the stock when the price went down. It's typically not sufficient just to allege or to prove that you purchased at an inflated price. You also have to prove that you held the stock and suffered a damage when the truth was disclosed. And then for some claims, there's another element of scienter, which is an intent to defraud, which is typically proven by showing knowledge of the speaker or some sort of motive to defraud, such as the large sale after the false statement and before the disclosure, the sale of a significant amount of insider positions or other elements that may have personally benefited the speaker or the alleged wrongdoer.